Hello everyone. In today's presentation, we are continuing with some important aspects of bail in case of juvenile offenders. We start with the grounds on which the bail can be denied to a juvenile. The general rule is that bail would be granted in all the circumstances. However, the bail can be rejected in certain exceptional circumstances which are provided in Proviso to Section 12(1) of the Juvenile Justice Act. The first exception to the rule of bail is that there appears reasonable ground for believing that the release is likely to bring the juvenile into association with any non-criminal. It is important to note that the terminologies like reasonable ground, non-criminals are not defined in the Juvenile Justice Act or the rules framed thereunder. However, it is a well settled rule of interpretation that in the absence of any statutory definition of the term used in a particular statute, it must be assigned the same meaning as commonly understood in the context of such act. Likewise, courts' decisions have also facilitated the interpretation of this exception. In Nand Kishore versus State in 2006, Delhi High Court has ruled that identification of criminal and prima facie case of nexus between juvenile and criminal is must. In another case of Manmohan Singh versus State of Punjab in 2004, Punjab and Haryana High Court ruled that objective assessment of the reasonable ground is must. Let us understand the meaning of certain words which has come out of the court's decisions. First word is association. To prove association, it must be shown that the persons so joined have a common purpose and that there is a mental connection between their related ideas. In the last, association cannot be inferred from a single act of joining a non-criminal. There should be sufficient evidence to show that the juvenile has been joining them regularly so as to give an impression that he would continue to join them in future also. Now we would see what courts have stated about non-criminal. It generally includes a person who habitually commit crimes, a person with bad criminal antecedent or criminal history, gangster, hardened criminal, those who repeatedly commits a particular type of crime. Considering the above definition, a co-accused with no criminal history or criminal antecedent to his credit, if involved in the crime with a juvenile, cannot be termed as a non-criminal. Now understanding the meaning of reasonable grounds for believing. The word reasonable signifies in accordance with reasons. Therefore, reasonable ground for believing is not same thing as suspicion, doubt or guesswork of the board. It is something higher. It is more than the prima facie grounds. It must contemplate substantial probable cause for believing the board that the release of juvenile is likely to put him under either of the three conditions or exceptions mentioned in section 12(1) of the Act. Further, this provision requires the existence of such facts and circumstances as are sufficient in themselves worth reasonably believing by a court of law. Now coming to the second exception to the rule of bail is that where the release is likely to expose the juvenile to moral, physical or psychological danger. In this regard, in an important judgment, the court has stated that whether the juvenile in conflict with law will be exposed to moral, physical or psychological danger is a fact or not This can be assessed only by the Juvenile Justice Board, and its members are trained to gauge the situation. Therefore, the court should not give a blanket order in all the cases to Juvenile Justice Board to release the juvenile in conflict with law on bail on the very same day of his production. Now coming to the third exception to the rule of bail, where the release of the juvenile would defeat the end of justice. Though it is enough to bring in consideration of gravity and heinous nature of the charge in case of a juvenile too, yet courts have given certain decisions where it is stated that the third exception has to be considered in the context of welfare of a juvenile. Further, courts have also held that it must be stated that how the release would defeat the end of justice. Though the courts are inclined in the favor of the welfare of the juvenile while granting bail to him, courts also have held that in case of gruesome crime committed by a juvenile above 16 years of age, allowing bail to the juvenile would defeat the end of the justice, and he cannot be allowed to take shelter of the provision just because he is short by some months of his 18th birthday. There are certain other important factors that need to be considered in a bail to a juvenile. First, in numerous cases, courts have decided that nature and gravity of offense are considered immaterial for bail. Second, the board must record its reason if it refuses to release the juvenile on bail. Third, provisions under CRPC and BNSS are not applicable to the bail application of a juvenile, which is under Section 12 of the Act. Fourth, order passed by different courts cannot be taken as binding precedents in bail matters pertaining to juvenile. Fifth one is that juvenile can be released without taking surety. Sixth, board has the power to modify the conditions imposed while directing release of the child on bail if such juvenile failed to fulfill those conditions. This series would be continued further to explain other important aspects of juvenile justice in detail. This would be helpful for all the individuals, including professionals in legal field. Do continue to watch this series and share your feedback by way of comments.